Federalist Paper for Canada, number 4, On the Path to Lawful and Peaceful Separation, by a citizen of the North. To the people of Canada, in the last paper I outlined the core principles upon which a new confederation of the free could be built. These were not abstractions, but a call to begin the deliberate creation of a new political order. If the current federation no longer serves its people, and if consent has been withdrawn, then our duty is not to complain within it, but to depart from it. This fourth paper addresses the means of separation, not through collapse or rebellion, but through calm, coordinated, lawful action. It is a truth seldom spoken in Canadian politics that we have every right, both morally and constitutionally, to walk away. The question now is not whether we may, but how we must. The right to leave is rooted in the right to self-govern. No people are born to be governed forever by the choices of the past. Confederation in 1867 was not a permanent chain, but a political arrangement entered into by provinces, many of whom held their own colonial or legal charters prior to union. If they could enter by agreement, they can exit by will. This is not sedition, it is self-respect. The Clarity Act is an affront to constitutional sovereignty. We must be clear, the Clarity Act is unconstitutional, illegitimate, and unenforceable. It claims to grant the federal government the authority to determine whether a province's referendum on independence was clear and whether separation may proceed. This is a legal fiction, dressed in democratic language. Nowhere in the Constitution Act 1867 nor the Constitution Act 1982 is there a clause that gives the federal parliament veto power over the will of a province's people expressed through democratic means. The very idea violates the core principle of federalism, that the provinces are equal partners, not subordinate departments of Ottawa. The Supreme Court of Canada's 1998 reference on secession did not say that the Clarity Act is binding law. It simply acknowledged that political negotiation should follow a clear expression of will. It did not require approval from Ottawa. The Clarity Act is therefore not a legitimate legal constraint. It is a political tool designed to confuse, delay, and delegitimize. We must not treat it as law. We must treat it as a boundary we are not required to recognize. Lawful declaration must be grounded in democratic legitimacy. The process must begin with clear, formal declarations of intent by provincial legislatures or representative assemblies. These must be backed by a public mandate either through referenda, petitions, or direct democratic mechanisms. The world must see that this is the will of the people, not the ambition of a few. A provisional charter must be prepared. Before any separation is declared, each participating province or region should adopt a provisional charter of rights and structure outlining how governance, court services, and transitions will be managed. This ensures order during uncertainty and proves that we're not destroying society, we are refounding it. Economic continuity must be secured through parallel structures. Central banking, revenue collection, trade, and contract enforcement must be transitioned carefully. We must immediately establish provincial treasuries, independent tax systems, and a plan for currency and investment continuity, whether that means launching a regional currency or adopting an existing one by treaty. Our prosperity must not pause. Institutions must be localized and shielded. Policing, healthcare, licensing, and courts must come under direct provincial control, with protections put in place to guard against interference by federal agencies during the transition period. It is critical that we stand up parallel institutions ready to function the moment the federal government's authority ends. Negotiation is a tool, not a permission slip. While it may be wise to negotiate terms, asset transfers, debt division, resource sharing, we do not require Ottawa's permission to leave. Negotiation should be pursued where it is in the public interest, but not relied upon as the only avenue forward. Our authority must not be contingent on federal approval. International recognition must be earned, not begged. Diplomatic teams should be formed to establish early contact with foreign governments, trade partners, and global organizations. Our language must be professional, peaceful, and rooted in the principles of democracy, rule of law, and self-determination. Canada will lose its legitimacy the moment we assert ours clearly and confidently. This path is not without hardship, but staying is not without consequence. To remain under a failing federation out of fear is to sacrifice future generations to permanent dependency and diminishing freedom. Separation will be difficult. It will be attacked. It may even be resisted. But if it is done with wisdom, unity, and moral clarity, it will succeed. And when we look back, we will not remember the chaos. We will remember that we stood together calmly and clearly and chose to build something new rather than be buried in something broken. In the next paper, I will address the challenges of fear, division, and doubt, and why they must never be allowed to override freedom. In solidarity and peace, a citizen of the North.